Good evening, friends. When we started this journey of legal sharing and other sessions, Mr. K. Prabhakar, an advocate from Madurai bench, Madras High Court, was one who we can say that patronized. And if we look into the playlists in respect of civil law, then we'll find that his sessions invariably have crossed 15,000 views. So that shows his knowledge sharing has been accepted by one and all. We are so glad that Mr. Prabhakar has accepted our invite and has joined to share his knowledge, though after quite some time. But they say that good things always take time. Thank you, Mr. Prabhakar, and over to you. The topic is Estoppel, Waiver and Acquiescence.
Thank you and good evening, Vikas, and good evening, friends. Quite a long time after probably 20, 25, 1 year before I was in this platform. Yeah, the topic, Estoppel, Waiver and Acquiescence. Quite interesting in a sense that Estoppel is a rule of law, whereas Waiver and Acquiescence are the conduct of the parties. If you want to make any distinction, Estoppel is spoken to in section 115, 116, and 117 of the Old Evidence Act. Waiver and acquiescence. Acquiescence is not spoken to except by judicial precedents, whereas waiver is spoken to is some of the laws, commercial laws, namely Trademark Act or the arbitration, or even in a small civil procedure code, etc., because waiver requires a positive act, whereas acquiescence is passive or a silent killer, rather. The core concept between estoppel, waiver, and acquiescence can be broadly categorized as estoppel prevents a person from contradicting a previous representation made. If a representation is made and if this representation is being acted upon and something has happened on the basis of this representation, the person who made a representation cannot go back. This is broadly section 115 of the Indian Evidence Act. It prevents a person or bars a person or shuts a person from taking a different view of the matter. It is a law of procedure or a rule of law. Whereas waiver should be intentional and voluntary relinquishment of a known right. Namely, if I am not aware of any right, the question of relinquishing my right does not arise at all. Secondly, waiver is all about active and conscious decision taken by a party. It requires a full knowledge of the right being disowned or abandoned. It can be viewed from the angle of a contract. It can create a cause of action for filing a case, whereas acquiescence doesn't create any cause of action. It is only a silent acceptance or failure on the part of the party to object to a violation of his right when it was available and allow the other person to steal a march over you. And thereafter, you cannot turn around. It is more of a passive asset or sitting by while rights are being invaded by other parties. It requires awareness of the right and the violation which is occurring. Acquiescence is more of a equitable doctrine, often considered as a species of estoppel. The estoppel is the umbrella, where the question of equitable doctrine applies on all fours. Waiver, we talk about in cases where there is a specific or active or unconscious decision has to be taken. And some of the act speaks about that if you keep quiet, notwithstanding the fact that you have got a right, and knowingly you allow the other party to move ahead, or you relinquish your right. Say, for example, under the Arbitration and Conciliation Act 1996 under Section 4 or Section 33, Clause 1 of the Trademark and Infringement Act. But in case of acquiescence, it is only a silent killer. It is not active but passive. These are the broad parameters of a distinction between estoppel, waiver, and acquiescence. But when we talk about the distinction, the first case which comes to my mind is Mahavir versus State of Uttar Pradesh, AR 1959, Allahabad, page 783. Why I am citing this? There are a lot of judgments on the score by all the high courts, as well as by the apex court, as well as the Privy Council. But this decision, according to me, makes a clear distinction between waiver and estoppel. If one person wants to understand both the concepts, where estoppel will come into play and where the waiver will come into play, this decision will give you the understanding of both the concepts. Namely, estoppel consists of an act or a representation you make. That means, therefore, you make a active disclosure or a statement, and on the basis of this, it can either be implied or expressed. But on the basis of this representation, somebody acts, and something has happened on the basis of this representation. And if it cannot be set back, clock cannot be set back, then the estoppel will apply on all fours. This is judgment in Mahavir versus State of Uttar Pradesh. The second judgment is the State Bank of India versus James, 2022, 2 SEC, page 301. This is also a similar case where the court has applied the principle of estoppel on the ground that once a representation has been made, then one cannot go back. But it's not all cases of waiver estoppel will come into play, or there is a overlap. Definitely, certainly, there will be a overlap between estoppel and acquiescence. But waiver is an entirely a different concept, in the sense we draw source or inspiration from a statute where a right is available, and then you waive that right, relinquish your right intentionally. Second, these types of concepts, namely whether it is estoppel, waiver, acquiescence, one has to plead. There is a difference between an admission and estoppel. What is an admission and what is an estoppel? You know, under the Evidence Act, the new Evidence Act, admission is not conclusive. What you can say, it can always be explained. You can go back upon the admission stating that in a set of circumstances I made this admission, I was wrong. You can show it as wrong. But estoppel is absolute. It's not that you can go back and say that I made a representation, but this representation is not correct or not true. You have no right choice at all. Kindly refer Chaganlal versus Narandas. Chaganlal versus Narandas, AIR 1982, Supreme Court, page 121. Chaganlal versus Narandas, AIR 1982, Supreme Court, page 121. The fact of the matter is, admission is always not conclusive. Second, even if an admission is made, the court is not bound to act upon such an admission. Secondly, even if there is an admission by one party, the court can ignore the admission, ask the other party to prove the case. These are all available under the Evidence Act. Therefore, the admission is only one piece of evidence. Of course, if an admission is made and if it is not withdrawn or explained or justified in withdrawing it, it is conclusive between the parties. One interesting question may arise. In a case or a trial, a party to the suit is examined, and subsequently a witness is being examined. A witness makes some statement. Whether this statement binds the party to the suit who has examined this witness. I'm afraid that a clear reading of the Evidence Act shows that the evidence of the admission of a party or a maker binds the maker alone. Thereby, you can always bring in a material to show that even though you are a sufferer, namely you are a party to the suit, your own witness turned against you and makes some admission. And you can always say that this admission made by the witness is not correct, is not justified, and it is not binding on the party and certain circumstances. Not that you can take such a stand in every case. But in case of an estoppel, it is absolute because the reason is estoppel comes into play only when four elements are satisfied. One, a representation has to be made, and on the basis of that representation should be made to another person. Three, on the basis of that representation, something has happened or the other party has done something. Four, the something which has happened in pursuance of that representation cannot be set at right or cannot be retraced. Then the question of estoppel will come. Assuming for a moment all these four elements are available in a particular case, it is satisfied. Can we say that the estoppel is not conclusive and therefore it is not binding? That there lies the distinction. Namely, if it is an admission, you can show it to be wrong. If it is an admission, you may be justified in saying that it is not correct because the circumstances under which I understood, I stated so. But in case of uh, estoppel, once the representation is made, and if all the four elements of estoppel have all been satisfied, then the party cannot go behind it. Three, when an estoppel can be taken into account, does it require a plea? Or is it enough to prove with the particular facts and circumstances of the case? Estoppel, though a rule of procedure or a rule of law or a procedure, it requires a pleading. The reason is that you cannot put the other man in a surprise. You must plead that in the factual, given the factual backdrop or the aspects, the party is stopped because these things have happened. And we can draw inspiration from the judgment of the Supreme Court in Jose versus Sivan Pillai, 1984, 2 SCC, page 12N. 1984, 2 SCC, page 656. 656. Jose versus Sivan Pillai, 1984, 2 SEC, page 656. Then we'll come to a representation made by a minor, whether it binds the minor. We all know that a contract entered into by a minor is void and unenforceable. But a contract in favor of a minor under Indian law is valid. Assuming for a moment a minor wrongfully represents that he is a major and purchases a property by giving consideration. Can we say after the consideration has been paid that the minor is not entitled to enter into a contract, therefore it is void? A contract which is beneficial to a minor is valid. Therefore, if a minor goes out and purchases a property by paying the adequate consideration, that this sale will be valid. But converse is not true. If a minor sells the property and the purchaser caveat emptor principle will come into play, the purchaser should be beware. And if the minor parts away with the property and swallows the money, still he has got a right under law to challenge the sale on the ground that he was a minor. Now, if these things happen in a particular case, can a minor pleads minority or he is being stopped from pleading minority? Gadigeppa Bhimappa Matti versus Balan Gowda, Bhiman Gowda, AR 1931, Bombay 561, full bench. Gadigeppa Bhimappa Matti versus Balan Gowda, Bhiman Gowda, AR 1931, Bombay 561. A full bench decision of His Lordship Bhiman. Before this judgment, there was some confusion that if a minor who is a beneficiary and if he enters into a contract fraudulently, can he plead minority or he is stopped from pleading minority? Some cases it was held by the other high courts that minor will also be stopped from pleading minority in the sense at the time of entering into a contract, I was only a minor, therefore it is not binding upon me. But after scanning several judgments, His Lordship John Beamont of the Bombay High Court in a full bench decision came to the conclusion that a minor is not stopped from pleading minority, even if the transaction is fraudulent. Because according to him, even if the transaction is fraudulent, the minor being a minor, the contract itself is void from the inception, and therefore the law does not prevent a minor from pleading that he is not a minor, he is not stopped. Very interestingly, before this judgment of John Beamont, there was also a full bench decision of the Lahore High Court. Khan Gul versus Laka Singh. Khan Gul versus Laka Singh. AR 1929. Lahore page 609. Lahore page 609. Another full bench decision. This decision also came to the conclusion that if the transaction is held to be fraudulent, notwithstanding the fact that if one of the party is minor, he is not stopped from challenging the transaction, that he was a minor and therefore it is not binding upon. These things will happen where a minor represents that he is a major, enter into a contract. And then subsequently, it was found that he is not a major but only a minor. These types of cases getting reduced day by day because transactions by a minor in the day of a digital world are coming down because everything requires your proof, identity, Aadhaar, and etc. Therefore, these types of cases automatically will come down. Probably it will drastically come down in another 10 or 20 years. Then the estoppel will also has to be taken into account at the time of filing the documents. A document, once it is admitted in evidence, the court is bound to take into account. There are only exceptions, namely, if the document lacks registration or the stamp duty has not been properly affixed in the document. If it is lack of registration, it can be questioned at any time. But in case of a stamp duty, under section 35 of the Stamp Act, the stamp the party who wants to object has to raise it before the document is admitted in evidence. If the issue with regard to stamp duty has not been raised and the court has not postponed its decision, namely with objections the document is marked, then the court has got a right to revisit. But if no objection has been made and the document has been admitted in evidence without recording the objection, either by the party or by the court, that it has to be decided at the time of final decision, then section 36 will come into play. The court has to necessarily look into the document. It cannot be taken out of the consideration by the court. The estoppel will come into play with regard to admissibility of documents, namely, if you doesn't object to the marking of a document or admitting a document on the ground of stamp duty or any other consideration, then you are precluded or stopped from challenging the admissibility of the document in the very same suit or in the proceeding or before the appellate court. Section 35 speaks about section 61, namely, if a document has been admitted in the evidence without the stamp duty being paid, the estoppel will come into play, then you cannot raise an issue. But before the appellate court has to consider the document, but it can send it to the appropriate authority under section 61 for consideration or slapping the stamp duty, whoever has to pay it with the penalty. The second admissibility of the estoppel will also come into play in a very interesting situation. One is, assuming for a moment, you are introducing a registered mortgage or a registered settlement deed or a gift deed. I'm not talking about a will, because will has got a special status under section 68 of the Evidence Act. The not being a will, if there is any admission, there is not be proved. Now, you introduce a settlement deed or a gift deed. Normally, who will present this document to the court at the first instance? It will only be by the beneficiary, not through the attesting witness or by a person who is the executant of the document. You should be vigilant that if you have denied the execution, attestation, and registration of the document, or the right to execute the document, or even the acceptance by the donee or the lack of acceptance by the donee in respect of a gift, then you should raise an objection at the time when the document was marked. I can very well remember one case, it is now before the High Court, where before the trial court a settlement deed was introduced in evidence. Under section 68 of the Evidence Act, it requires a proof by examining at least one attesting witness. But unfortunately, the attesting witness was not examined. The document was marked or admitted. The court also considered the document and pronounced the judgment. Thereafter, before the appellate court, a plea was raised that the settlement deed has not been proved in accordance with the law under section 68 by examining at least one attesting witness, and therefore it is an inadmissible document. But the estoppel in such cases will come into play. The reason is, if a beneficiary or the person or a donee who introduce a document, he is not an attesting witness, therefore you should be vigilant to object to the marking of the document stating that he cannot introduce the document, the attesting witness has to be examined. And if you leave that open, and thereafter, even during the course of the trial or the subsequent proceeding in the suit or before the appellate court, you will be stopped from challenging the document on the ground that the attesting witness have not been examined. I remember there is a judgment in year 1942 Privy Council by offhand, if I can quote, and subsequently followed. But very recently, the Honorable Apex Court considered this admissibility of the documents and the principle of estoppel in RVE Arunachala Counter versus Arulmigu Visveswara Swami Temple, AR 2003, Supreme Court, page 4548. Arunachala Counter versus Arulmigu Visveswara Swami Temple, AR 2003, Supreme Court, 4548, where the Lordship would analyze or scanned several judgments and came to the conclusion that in case of proof that a particular document has not been proved in accordance with the law by examining the attesting witness under Section 68 of the Old Evidence Act, or if there is no attesting witness, by invoking the provisions under Section 69 and 71. But that option of putting the burden upon the other party to prove the document will evaporate the moment you did not or failed to object at the time of marking the document. You will be stopped. Therefore, keep it in mind that once a document is being tried to be exhibited or admitted in evidence, raise an issue that this document has not been proved in accordance with the law, it has to be proved in accordance with the law, and subject to that objection alone, the document can be admitted in evidence through a beneficiary or through a donee. Then another estoppel by attestation. This is a very interesting question because there are judgments on either side. But what is estoppel by attestation? Normally, in rural India, if you have got a semblance of right or a minuscule of right, or if the other party who enters into transaction want to ensure that you should not raise any claim with regard to title or possession in respect of a document or a conveyance being executed between two parties, they normally invite you to attest the document. This attestation would be taken into account as a token of acceptance of the transaction between the parties, and the attester has nothing to do with the document. Very interesting case was one of the oldest judgment of His Lordship Subramania Iyer of the Madras High Court, reported in Kandasamy Pillai versus Rangasamy Naina, 1912, MLJ page 301. 1912, MLJ page 301. Where is Lordship, after scanning the interesting facet of this estoppel, attestation, etc., also made an observation, that observation in his personal capacity. Now, we have crossed a stage where the judges are not supposed to write in the judgment their personal experiences. But in that judgment, if you see His Lordship Subramania categorically asserted that in this part of the country, normally attestation will be obtained by a person who may claim, and he should be precluded from making a claim. Therefore, he will be asked to attest the document only to approve the transaction between two parties is true and valid. But attestation by itself will not impute knowledge, because attestation, as defined under the Transfer of Property Act or any other act for that matter, shows that the attesting witness must see the executant signing the document, and the executant must see that the attesting witness also signed, or either of them should acknowledge their signature. Either it should be in their presence when they affix their signature. The attesting witness saw the testator or the executant affixing his signature, and conversely, the executor or the testator seeing the attester signing the document or affixing his thumb impression. These are all the definition of an attestation. Therefore, what it speaks about is about the attestation is only a concept to admit that some X has affixed his signature or affixed his thumb impression in the document. He is not supposed to read the contents of the document or supposed to have knowledge of the contents of the documents. Contents is irrelevant insofar as the attesting witness is concerned. Therefore, one of the oldest judgments is 9 years or nearly 10 years after the judgment of His Lordship Subramania Iyer, the Privy Council in Panduranga Krishanji versus Markandeya Tukram. Panduranga Krishanji versus Markandeya Tukram. Reported in AIR 1922 Privy Council page 20. AIR 1922 Privy Council page 20. Where the Lordship has held that the mere attestation will not impute knowledge. Correct. But can we say that an attestor is estoppel from challenging the document or challenging the title of the parties who are involved in the document in which he was an attestor? It will trickle down to the fact. If we are able to establish that the attesting witness is not a mere attesting witness with regard to the signature or the thumb impression, but he had got knowledge of the contents of the document, or the circumstances show that he had got knowledge and therefore he signed as an attesting witness, then alone the attestation will stop a party from challenging it subsequently. Then what is issue estoppel? Issue estoppel can be loosely spoken to as res judicata under the Civil Procedure Code. In Tode versus Tode, His Lordship Diplock of Britain reported in the All England Reporter 1964-1, page 341, cited three ingredients for invoking a issue estoppel. What is a issue estoppel? Issue estoppel is an issue which has already been raised in a previous proceeding or an earlier proceeding before a competent court of law, and a decision has been rendered, and this decision has been rendered on merits. A finality has been reached on merits by a competent court. Therefore, what His Lordship Lord Diplock would say, the three ingredients have to be satisfied in case the issue estoppel has to be raised. One is a competent court, decision by a competent court. Then it reaches a finality. Third, it is on merits. It what we call as an issue estoppel. But under the law of civil procedure code, res judicata is different from this issue estoppel. Issue estoppel, only three things are required. You can raise an issue, namely it has been decided by a competent court, finality reached, and on merits. But this issue, which has also to be an issue before the earlier. Now coming to res judicata principle under the Civil Procedure Code, section 11, it should be between the same parties, one, or parties claiming under them, two, same cause of action, three, directly and substantially in issue, four, finally decided by a competent court. Five things are required in case of a principle of res judicata. But the difference between issue estoppel, which Lord Diplock spoke in 1964, one All England Reporter, page 341, and res judicata, which we contemplate, yes, it is res judicata will apply even if the decision is not on merits, provided the judgment is a degree and judgment as contemplated under the Civil Procedure Code. One can say that there is a march of law, where earlier there was the expanded degree, the court will not even exercise that mind. What we will say, PW1 examine, exhibit A1 to A5 mark degree as spread for. Now the courts have come to a conclusion that this degree is a big chunk. A degree by a court without exercising its mind. Even if the other party did not come to the court, a degree must satisfy the definition of a degree as contemplated in Section 2 of the Civil Procedure Code. And if it, even if the the other party has not filed any return statement, and no issue could be framed, then also law mandates as of today that a point for consideration has to be raised and an answer has to be made after discussing the documents filed by the plaintiff. Where we are heading. Original jurisprudence of this country is adversarial jurisprudence, namely, the courts have no role to play. It is only an adjudicating authority on the basis of the matter presented to the court by both the parties. But now this type of ex parte judgments are being trashed as a junk, and therefore the court have to decide the matter whether the defendant is there or not. Means that we are moving away from an adversarial jurisprudence. What is an adversarial jurisprudence? If a party comes to the court and present this case or present this document, the court need not be vigilant. It is the party or the other party to the list who should be vigilant in stating that this is wrong, this document is not correct, etc. It is not for the court to make an investigation. The court is only an adjudicating authority and it is not an investigator. That is a general principle of adversarial jurisprudence. But I am afraid that this distinction between an investigator and adjudicator have all slowly getting blurred because the courts have become proactive and day in and day out we see the judgments which are being thrashed outside by the media as a judicial overreach. But the society is now moving towards a direction that people expect the judiciary to take a proactive role rather than involving itself as an adjudicator in an adversarial jurisprudence system. Now, coming to the application of Estoppel in the context of a family arrangement between parties. There are several judgments of the Supreme Court as well as by the very many high courts that a family arrangement is to bring peace and harmony within the family, and therefore it has to be given an authentication by the court provided it is true. The procedural lapses and the procedural safeguards have all to be have all to receive to the background when you say that a family arrangement is to be whether it is true or not, meaning thereby the procedure is only an handmaid of justice and therefore it need not be given a full force or a application on all force in case of a family arrangement if it brings a peace and harmony. Thereby, the procedure can recede to the background. And if a family arrangement is put forth before a court of law, and if the court finds that the family arrangement, whether it is oral or whether it has been subsequently reduced into writing, though not it has been registered, the court can still rely upon this family arrangement on the principle that the party who involves himself in the family arrangement is stopped from challenging the same. Straight away, this family arrangement which was given authentication was an Hardy versus Bhagwan Singh, AR 1919, Privy Council, page 27. Hardy versus Bhagwan Singh, AR 1990, Privy Council, page 27. And subsequently, in 1971, there was a judgment of the Honorable Supreme Court, wherein the lordship, in 76, there was a judgment in case of a partition where the family arrangement was upheld by the court. If I remember correctly, it was a college case in 1976 Supreme Court, where the court has held that a past transaction, if it is reduced into writing, does not require any registration, then it can be relied upon and Estoppel other party who also acted upon such a family arrangement. This family arrangement or a oral family arrangement can also be applied to a case of a family arrangement among the Mohammedans. It's not as though, because under the Indian context, the original civilization or the culture all one and the same. Their lordship in Lahore applied this principle in Amir Hassan was Amir Hassan versus Muhammad Ijaz Hussain. AIR 1927, Lahore, page 16. Amir Hassan versus Muhammad Ijaz Hussain, AIR 1927, Lahore, page 16, where the lordship would say that notwithstanding the fact that the parties are Mohammedans, a family arrangement among the members of the family will raise a issue of estoppel, barring a party from challenging this same. Very recently, when this Act 39 of 2005 was put into rest by Arun Mishra in Rajendra Grau's case, the Lordship has said that yeah, a partition, a oral partition, though the exception has not been carved out under 39 of 2005, namely 6.5, where it says it will apply only in case of a registered partition or a testamentary disposition which has happened before 20th December 2004. The Lordship has held that family arrangement or a oral partition which has happened, which was valid under the earlier law, cannot be reopened because a right already vested, and therefore it cannot be trashed on the ground that the law under Act 39 of 2005 speaks about only a registered partition. An exception has been carved out, and therefore a oral family arrangement reduced into writing subsequently, or even if there is no uh, written document, whether it was subsequent or not, if a party is able to establish that there was a oral partition or a family arrangement, the other party will be estopped. Now coming to estoppel and fraud. What is estoppel and fraud? Just imagine if one of the parties to the contract commits a fraud, or both the parties commit a fraud, or three, both the parties or any either one of them tried to commit a fraud, but execution could not be carried out. Three scenarios. If a party commits a fraud, he cannot take the indulgence of the court because in pari delicto, there is a principle called if both the parties commit a fraud, the court will not authenticate the act of fraud by giving judgment in favor of one. Therefore, if the court finds that both the parties have committed a fraud, the question of estoppel does not arise. The court will thrash both. And if a fraud has been proved, but it has not been carried out in execution, then there is a element of an escape route. Yasamatti Krishnaya versus Chundru Papaya. Yasamatti Krishnaya versus Chundru Papaya, ILR 1897. Volume 20, Madras, page 330. ILR 1897, volume 20, Madras, page 330. Where if a fraud has been planned, proved, but it is yet to be executed, then the party can wriggle out of the situation, say that I am not estopped, I can say all these things. Then the all important equitable estoppel. The interesting principle of equitable estoppel. I can give you a colloquially, there are several judgments, and just I'm giving you an example. Suppose I have got a vacant plot to my property, which is a building. Then this vacant plot is sandwiched between two houses, assuming for a moment A and B are the owners. In between the properties, there is a plot, the vacant plot. I thought that this plot belongs to me. I started putting up construction. And the other man who is on the other side of this plot also thought that this plot belongs to me. He kept quite often he will come to my home and say, what is the nature of the construction, what is the quality of the tile you are putting, and what is the quality of the wood you are using for windows, etc. Thereafter, he has also attended the housewarming ceremony. Subsequently, B found that I am not the owner or A is not the owner, that he is the owner of the property. Can he file a suit for recovery of possession? The law says there are several judgments. One would say that he is bound by the principle of acquiescence and estoppel. The man silently keeps quiet or making a representation that the other man is the owner, encouraging him to put up construction, and thereafter he cannot go back. This line of decision, I can say, Associate Cement Company versus Ramakrishna Counter, AIR 1965, Madras, page 318. Associate Cement Company versus Ramakrishna Konar was AIR 1965, Madras, page 318. There is a case where the court has applied the principle of estoppel and acquisition, barred the party from recovering the property, and has also gone to the extent of stating that he is not entitled to damages also. The earlier judgment on that aspect was Sita Raman versus Jayaraman, 2014 Supreme Madras, page 1190 of His Lordship Doraisamy. The third judgment is the recent judgment of Supreme Court in Pratima Chaudhary versus Kalpana Mukherjee. Pratima Chaudhary versus Kalpana Mukherjee. AR 2014 Supreme Court, page 1304. Where a different tone has been set, where the Lordship would say that if a party comes to the court within the period of limitation, then the question of applying estoppel does not arise unless there is a positive representation made, namely, mere acquiescence may not be enough to prevent the other party from recovering the property. The acquiescence amounting to estoppel alone can prevent the party. Then there is a provision under section Transfer of Property Act, section 51. That is also the question of estoppel can be applied or not. The court has held very recently that if you take or invoke section 51, the question of applying the principle of estoppel does not arise. Vaini Prasad versus Durga Devi, 2023, 3 SCR, page 282. Vaini Prasad versus Durga Devi, 2023 SCR, page 282. Where the Lordship would say, section 51 speaks about a person putting up a construction or enjoying the property of the other man. A site belongs to one, superstructure belongs to the another. It is this superstructure or improvement was made on the basis of a defective title. It's not that I'm putting a property on the other man's property or putting up a building or a superstructure on other man's property. It was a case where if you want to apply 51, you go ahead and purchase under a particular document. But your vendor has got no title. You enter possession, started putting up construction. Thereafter, the original owner comes to the court. There is a dispute. The court finds the other man is the owner. If the court finds that the other man is the owner, can you take advantage of section 51 or estoppel? The court says that if you want to stick on to estoppel, the question of 51 does not apply at all. 51 will apply only in cases where you enter possession on the basis of a defective title and put up construction. If you want to go under section 51 of the Transfer of Property Act for the improvements made, then the option is both. The person who put up the superstructure can buy the site, or the person who is the owner of the site can buy the improvements made over the site. But if you take the route of 51, you cannot take the route of estoppel. Therefore, be conscious of the fact, stick to one, kick the other. Stick to one, kick the other. Either you take the principle of Estoppel or you take the principle of Section 51 of Transfer of Property Act. But both of them cannot sail together. Both of them are mutually exclusive, destructive, diametrically opposite. Now coming to arbitration conflict, I have lined up. Section 4 of the Arbitration Act and 12.5. Now the very recent decision of the 5 judges of the in court, Lordship Chandrachud has held that 12.5 will apply almost retrospectively, except in case of a 3-member decision. It has thrown overboard Section 4 of the Act. What Section 4 says, if there is any question about the constitution of the arbitration tribunal, it has to be challenged before filing the written submission by way of a defense. You have to raise it at the first instance. If you doesn't do it, then Section 4 waiver will kick in. If you go and participate in the proceedings, thereafter, normally you are not supposed to take such a plea that the composition of the arbitral tribunal is not valid, not in accordance with the law under Section 34. The route is there. Either you take the principle under Section 14 or Section 16, challenge it before the tribunal, and then if you suffer, go ahead and challenge it under Section 34. But his lordship in core railways cases in a 5-judge bench, 3 judges have held that only in case of 3 judges, this cannot be reopened. Otherwise, a party, even if the party autonomy is spoken to, if 12.5 has not been complied, the waiver under Section 4 will not apply. What is Section 12.5 speaks about is the relationship of the arbitrator between the of the arbitrator with one of the parties. Even a unilateral appointment made by the party, namely one of the party to the contract, reserves his right. It all happens in public sector contracts, where an arbitrator is being appointed by one of the parties. It was held to be valid before this court case in 2023. But now the march of law says that under 12.5, it is not possible. But subsequently, we have also got 2 judgments. One of them is Municipal Corporation of Greater Mumbai versus Anderson Associates Limited 2026 3 SCR page 525. Municipal Corporation of Greater Mumbai versus Anderson Associates Limited 2026 3 SCR page 525. This can also be a case where if the proceeding have commenced under the unamended Act of 2018, before 2018 Act, then the proceedings cannot be tested on the touchstone of the decision of court. Notwithstanding the fact that the core has not been cited before his lordship Maheshwari, he has held that once the arbitration has commenced under the old act, the question of applying these principles does not apply. But the fact is, waiver speaks about one thing under Section 4. Under 12.5, the party has to, after the appointment or the constitution of the arbitral tribunal, consciously you should waive his right in writing that I have no objection for this arbitrator to continue. If this is not available, then the waiver under Section 4 will not cure that defect. Therefore, but still the law is developing. According to me, Section 4 has got a different take and 12.5 has got a different take. But if constitutionally tribunal is not challenged under Section 4, my humble view is 12.5 will not come to the aid. 12.5 will come to the aid only in case where there is a violation of 12.5 7th schedule, where the appointment of arbitrator is in violation of the principles constituted under the 7th schedule. Then the last, and I wind up. In civil procedure code, there are 2 provisions. One is Order 1, Rule 13, where if objection with regard to the non-joinder of the parties and necessary parties has not been taken at the earliest, then a suit cannot be dismissed on the ground. Commissioner of HR&C versus Ratna Verma Temple, Commissioner of HR&C versus Ratna Verma Temple, 1969 to Mysore Law Journal, page 23. Mysore Law Journal, page 23. Well, the objection has to be raised at the earliest point with regard to the non-jointer parties. It cannot be thereafter taken into account. Then, Section 80 CPC, there is also a waiver. Section 80 notice is mandatory in case a relief is sought for against the government. But if the government keeps quiet and did not raise an issue, because it is a benefit given to the government, any benefit given to a particular party, that party is entitled to waive it. And Section 80 CPC is no exceptions. Thank you for listening. I leave the podium to Vikas, my friend Vikas.
You have already kept everyone spellbound, but still there are certain questions that you have explained. The Estoppel, Waiver and Acquiescence, the differences. But you have also explained, but somebody wanted a specific question only on this point. What is the precise distinction between Estoppel, Waiver and Acquiescence, particularly in the legal effect on rights? A short, so that it becomes a summary. Hello? Hello? Is it audible? Hello? Hello? Is it audible? Your mic is not connected, Mr. Prabhakar. Hello? Mr. Prabhakar, tell me. Just hold on. Is it audible? Mr. Prabhakar, is it audible? I think you have not connected your audio. Just check it out. Yeah. Now is it audible?
Yeah.
Yeah. Just hold on. It says, though you have taken up, can estoppel operate against a statute, or is it strictly confined to representation between the parties?
Estoppel cannot operate against statute because the power of the legislature cannot be taken away by any conduct of the parties. Therefore, it is only with regard to the conduct of the parties, this principle of estoppel will apply. Estoppel against statute will not apply. Estoppel against facts also will not apply.
Next is, how does promissory estoppel differ from traditional estoppel under the Evidence Act?
Yeah, promissory estoppel in cases will come into play in case of a promise made by the government. In case of an estoppel, it will apply to everybody. Promissory estoppel in the sense, in many cases, the government will promise certain things for a certain industry. Where, if I remember Motilal Sugar Mills case somewhere in the 80s, where a promise was given by the government. And thereafter, they tried to wriggle out of the situation where the court held that the promissory estoppel will come into play in case of a governmental action, administrative actions, but not in respect of a legislative action.
Then another is there any distinction between promissory estoppel and legitimate expectation?
Promissory estoppel and
legitimate expectation.
Yeah, estoppel and both operates in a different field. Expectation cannot, legitimate expectation cannot elevate the status of an estoppel. Expectation is by one party, whereas estoppel from the other party. I expect something, and this is called as a legitimate expectation on the basis of some behavior earlier. But estoppel is a positive act by the other party. There should be a representation, but in case of a legitimate expectation, there need not be a express or implied representation by a party, because estoppel requires a representation either express or implied, and then subsequently it has to be acted upon. And once something has been done, it cannot be retraced. But legitimate expectation operate on a different field.
Yeah. Can the state invoke estoppel or waiver against a citizen, particularly in matters of fundamental rights?
No.
And sometimes we say that an issue is framed and one does not press upon it during the civil suit. Will it act as an estoppel, or still that issue can be pressed in an appeal?
Once the parties go into the trial, knowing the entire facts of the matter and the opposite party, what he is going to place before the court, merely because an issue has not been framed, that doesn't preclude a party. Because issues are only issues to the court to decide. Still, the parties can let in evidence on the basis of the pleading. And the court is also entitled to take or decide a matter, notwithstanding the fact that there was no issue framed. Because if both the parties
it is on
are
a different
conscious
point.
of the
An
fact
issue has been framed,
in,
but can you say in an appeal that this issue I would like to play because that the lawyer had foregone it, but otherwise it has a legal semblance?
Yeah, the question is very difficult. In fact, we don't have any straight answer for that. But the point is, once you not press the issue, the question arises whether a party cannot press the issue. The party can only raise an issue. It is for the court to decide which are the issues to be decided. Therefore, merely because a party not presses an issue doesn't preclude the court, according to me, from deciding the issue even before the appellate court.
We will check out if you share some case law on that aspect. Yeah. So, Mr. Prabhakar, it was a wonderful treat for thoughts and for the mind. Though we had done one session with Chief Justice Prios from Kerala, but still you have given a deeper insights and a different perspective. We have all cherished that session, and we will stay connected with you so that we can have more sessions with you. Thank you. May you succeed in the profession and personal life. Thank you.